Hi everyone, and welcome to Session 3, Business and Human Rights, an important focus for advocacy. To begin, I would like to acknowledge the traditional custodians of the many lands on which we meet today and pay our respect to the elders past and present. Our speaker today is Madeleine Bridgett. Madeleine is an international human rights barrister. She is the co-chair of the Business and Human Rights Subcommittee for the Australian Lawyers of Human Rights and a member of Human Rights Committee for the NSW Bar Association. She is also a member and a past chair of ETAC's Australian Committee. Madeleine has published work in both national and international journals and has presented at conferences globally. She has been invited to give evidence at parliamentary inquiries on business and human rights, modern slavery, and organ trafficking. Madeleine is known for her fearless and unrelenting advocacy in the areas of human rights and international law. So let's welcome Madeleine.
Thank you very much, Anshu. Welcome, everybody. I can't see you, but I know that you can see me. And so thank you very much for attending. It's very early here in Sydney, Australia, and I believe there are people from all around the world attending this morning. So I am going to be giving very much an overview of business and human rights. It's quite 101, quite basic, but I thought we would start with that. And then, of course, if people feel like they want a little bit more in-depth education and training around business and human rights, I'm always happy to come and do another session. I'm just going to share my screen with you now. So I've called this session Legal and Policy Framework for Business and Human Rights because I think it's important to understand the actual framework for business and human rights, what it means. So the first place to start is the Universal Declaration of Human Rights. It's very important that if you want to know more about business and human rights, that you know about what are human rights. A lot of businesses, and it's a term that's used a lot more frequently these days. I'm not sure that everybody who uses the term knows exactly what that term means. So it's important that you understand, what do we actually mean by human rights? If we expect businesses to adhere to human rights, we need to know ourselves what are the human rights that they should be adhering to. So the first place that you start with is the Universal Declaration of Human Rights. That was one of it's an international document that states basic rights and fundamental freedoms to which all human beings are entitled. It was adopted by the General Assembly of the United Nations on the 10th of December 1948. It came as a result of society and communities feeling that the United Nations Charter, which came after, during World War II, there was the speech by Franklin D. Roosevelt in 1941. He delivered the State of the Union address, which became known as the Four Freedoms speech. The United Nations Charter was formed. It reaffirmed faith in fundamental human rights and dignity and the worth of the human person. And it committed all member states to promote universal respect for and observance of human rights, fundamental freedoms, for all without distinction as to race, sex, language, or religion. But there was a sense in the world community that the United Nations Charter just didn't sufficiently define the rights to which it referred. And so a universal declaration that specified the rights of individuals was necessary to give effect to the Charter's provisions on human rights. And so was formed the Universal Declaration of Human Rights. It is a milestone document. It's an important document that people should be familiar with. You can actually get a little pocket-sized version of it. I carry it with me wherever I go, particularly if I'm travelling through airports and I'm pulled over, if I am pulled over. And it's really important to know what your universal human rights are. and it's enshrined in this document. So yes, so it was the first time that countries actually agreed upon a comprehensive statement of inalienable human rights. It is not a treaty. It is not binding. It doesn't create any legal obligations for states. The declaration has, however, had a profound influence on the development of international human rights law. It's argued that because states have constantly invoked the declaration over more than 50 years now, or it's more than 50 years now, it's become binding as a part of customary international law. So what are human rights? Human rights are inherent to all human beings. What that means is you are born with them. It's not something that you're given through a law or through a policy or a standard. They are inherent to you as a human being. You have them, whatever your nationality is, whatever your place of residence, your sex, your national ethnic origin, your religion, language, or any other status. Okay, we're all equally entitled to human rights without discrimination. So they say that you often hear when people are talking about human rights that they're universal, they're inalienable, they can't be taken away from you. Okay, you're born with them as a human being. They're interdependent, they're indivisible, and it's about equality and non-discrimination. Those terms are really important to understand because human rights are different to other rights and obligations that we're often given as a result of legislation. Human rights are something that you're born with and nobody can take those away from you. So what happened after the Universal Declaration of Human Rights? You'll see there that you often hear the term International Bill of Rights, and that encapsulates the Universal Declaration of Human Rights, the International Covenant on Civil and Political Rights, and the optional protocol to the International Covenant on Civil and Political Rights, the International Covenant on Economic, Social and Cultural Rights, and the optional protocol to the International Covenant on Economic, Social and Cultural Rights. On the right-hand side, I've used this slide when I've been presenting to people here in Australia, but every country who has ratified the covenants, the treaties, if you like. Some people refer to them as covenants, some people refer to them as treaties. You will also be able to go on to the United Nations website and you can have a look at when your country ratified those conventions. There is, in terms of international human rights instruments, they consist of more than over 100 treaties, declarations, guidelines, recommendations and principles. So when we talk about international human rights laws and standards, you will find them in various different documents or different instruments, if you like, is another term that's used. They're documents, they're there to enshrine the human rights laws. So what are some of the key rights that you'll find in international human rights law? The right to self-determination, the rights of Indigenous peoples, the prevention of discrimination, rights of women, rights of the child, rights of people with disability, rights to a family life, rights to health, rights to fair and safe conditions of work, rights not to be subjected to slavery-like practice or forced labour, rights of migrants, international criminal law, international humanitarian law. There's also the right to be free from torture and inhumane and degrading treatment or punishment. So what human rights do businesses need to protect? Well, businesses need to protect all human rights. But when we think about, well, what are some of the particular human rights that would be more prevalent when businesses are conducting when companies or entities are conducting their businesses? Right to life. So if you're conducting a business or you're providing a service or you're producing a product, any form of business, you need to consider whether your business has an impact on whether they're at risk of perhaps losing their life. So right to life, rights not to be subjected to slavery-like practices or forced labour, a very important right when we're talking about China and China's human rights. Internment camps. Most internment camps would breach and would be a serious breach of people's human rights who are subjected to slavery-like practices or forced labour. The right to water, we take it, we probably take that for granted living in countries where water is so accessible and we have it just by turning the tap on, literally. But not all countries have access to water. Right to the child, and again, including forced labour, very important right when it comes to businesses. And we've seen that over the recent years where companies are being called accountable to using children, in particular using child forced labour. Rights to just and favourable conditions of work. So hours, wages, making sure people are actually paid for the work that they do. There's some of the key ones when we think about what are the human rights that businesses need to protect. There is no international treaty on business and human rights. There is a draft at the moment sitting there with the United Nations. It's in second draft. It has a very long-winded title. It's called the Legally Binding Instrument to Regulate in International Human Rights Law the Activities of Transnational Corporations and Other Business Enterprises. It is still not a treaty as yet, and it's in second draft. So if there is no international treaty on business and human rights, where do we go to find out what are some of the principles, standards, policies that businesses need to use to ensure that they're engaging in responsible business conduct? So we start with the United Nations Guiding Principles on Business and Human Rights. So the United Nations Guiding Principles on Business and Human Rights were adopted by the United Nations in 2011, and it signalled an international acceptance that the corporate responsibility to respect human rights exists independently of and as a complement to the state's duties to protect human rights. So it's one of the first documents that has actually said that businesses have a responsibility to respect human rights. It's a very important document. I would encourage all of you to read it. It's not a long document. You can see there that there are 3 pillars, and the document refers to these 3 pillars. Whenever we refer to the United Nations Guiding Principles on Business and Human Rights, we talk about the 3 pillars. The first one is for the state. They have a duty to protect human rights. The second is the corporate responsibility to respect human rights. So that is that is where the businesses have a responsibility to respect human rights and access to remedy. So what happens when a business is found to breach or violate a human right? What access does somebody has to remedy? And we're going to talk a little bit about national contact points later in the session as a form of remedy. Because there is no international treaty, the remedies that people have at the moment are mainly non-judicial remedies. So that will be done through mediation or alternative dispute resolution, through perhaps conflict resolution processes within companies and within businesses. And so they're the scope of the remedies generally at the moment. The judicial remedies are fairly limited, and some people would argue that non-judicial remedies may have a greater impact than judicial remedies. So this now takes me to the OECD Guidelines for Multinational Enterprises. The OECD stands for the Organisation for Economic Cooperation and Development. Again, this is a really important document, and I would encourage everybody who's doing any form of advocacy in human rights, and particularly dealing with human rights in China, to look at this document. The OECD is an international organisation that works to build better policies for better lives. That's how they describe themselves on their website. Their goal is to shape policies that foster prosperity, equality, opportunity and well-being for all. So the OECD works with governments, policymakers and citizens, and they work on establishing evidence-based international standards and finding solutions to a range of social, economic and environmental challenges, from improving economic performance and creating jobs to fostering strong education and fighting international tax evasion. They provide a unique forum and knowledge hub for data and analysis, exchange of experiences, best practice sharing and advice on public policies and international standard setting. So one of the documents they have produced, which sets international standards for multinational enterprises, are the OECD guidelines. And you can see there as well that I've also put down the International Labour Organization. I'm not going to be speaking too much about the ILO. Needless to say that the ILO is an extremely important organisation that produces international labour standards. They're legal instruments drawn up by the ILO's constituents, governments, employers and workers, and they set out basic principles and rights at work. Again, a very, very important document. There's no reason why I'm not focusing on that today except for time. So I would also encourage you to go to the ILO website and have a look at some of their legal instruments that specifically talk to the right, fair work conditions, rights for workers. So before I talk about the national contact centres, I just want to talk a little bit more about the guidelines, the OECD guidelines. So the OECD guidelines are they're recommendations addressed by governments to multinational enterprises. So they set out standards to multinational enterprises to say this is how you should be conducting your business. They're the most comprehensive international standard on responsible business conduct. The guidelines reflect the expectation from governments to businesses on how to act responsibly. They cover all areas of business responsibility, including human rights, labour rights, environment, bribery, consumer interests, as well as information disclosure, science and technology, competition and taxation, as well as human rights. I think I may have mentioned that, but they have a particular section on human rights in the guidelines. The guidelines provide, once again, they're non-binding principles, so they're not binding on any states around the world, but they are standards for responsible business conduct in a global context consistent with applicable laws and internationally recognised standards. They provide principles and standards of good practice consistent with applicable laws and internationally recognised standards. The guidelines are the only multilaterally agreed and comprehensive code of responsible business conduct that governments have committed to promoting. So within the guidelines, you will find some of that there is a whole section on general policies. So it talks about what businesses, how they should conduct themselves when it comes to general policies. And then there is a whole section on human rights. To say, and their human rights framework talks about respecting human rights. So businesses need to respect human rights, which means that they should avoid infringing on the human rights of others and should address adverse human rights impacts in which they are involved. And you can see there that relates very neatly to what's now what you will hear being called in business and human rights in that field. You will hear the term human rights due diligence. Okay, so businesses are required under these guidelines. I say that it's good practice, it's an internationally recognised standard that business should undertake human rights due diligence when they're undertaking their businesses. So they need to have a look at their businesses and say, Is there anything that we're doing in the way that we run our businesses that has an adverse impact on a person's human rights? And it could also be a community's human rights. So a good example is the spilling of oil in the Niger Delta in Nigeria, where Shell has been found liable for breaches of human rights, particularly around destroying people's communities from fishing and farming. So the international standards on responsible business conduct is very, very important when it comes to upholding and adhering to human rights. So I'd encourage you all to have a look at that document. The guidelines also say that businesses should have a policy commitment to respecting human rights. So you will see now that a lot of businesses will have what's called a human rights policy. And you can go onto a business's website if you think that a business is not engaging in responsible business conduct or perhaps a breaching human rights. You can go onto their website and have a look and see if they actually do have a human rights policy. They should be, businesses are now making them visible and accessible on their websites. And I'll come back to that policy a little bit later in the session when I talk a little bit about modern slavery legislation. So businesses are expected under these guidelines to carry out human rights due diligence as appropriate to their size, the nature and context of operations, and the severity of the risks of adverse human rights and impacts. They're to provide for or cooperate through legitimate processes in the remediation of adverse human rights impacts where they identify that they have caused or contributed to these impacts. So what the guidelines are saying is not only do businesses need to undertake due diligence assessments or assess those risks, they also have to have in place how are they going to remedy those risks. So what are their remedies? What do they do to remedy those risks or the adverse impacts? Let's just say they do the due diligence risks, but they actually identify that this could have could have an adverse human rights impact. What is our business? What do we have in place to remedy those impacts? And human rights due diligence is about. It's not just about identifying impacts that might be happening right then and there, but it's also about preventing those impacts. So it's also about doing a risk analysis to say, okay, what are some of the human rights risks of this kind of business that we're undertaking at the moment? That now takes us to national contact points. Most countries will have a national contact point centre or national contact point. They don't call them centres, but let's just call them national contact points. Most countries will have a national contact point. I would encourage you again to just have a look on your website, put national contact point and the name of your country and see if you have a national contact point. The national contact point is a government-supported office whose core duty is to advance the effectiveness of the guidelines. The national contact points advance the effectiveness of the guidelines in two ways: by raising awareness among businesses and other stakeholders about the guidelines, standards, and the grievance mechanisms, and by handling specific instances, so grievances or complaints, if you like to call it that, against companies who allegedly have failed to meet the guideline standards. So let's take an example. If in your country you come across a business who may be, for example, dealing with a company that's based in China who you know is using forced labor, for example, or is dealing with or associated with or providing services or products to internment camps, whether that be the chairs that people are sitting on in those internment camps, whether it's pens that people are using, whether it's the gates, whether it's the steel that has been made for those internment camps. And in your country, a business is dealing with a company that is known to be dealing with or engaging in businesses that either fail to meet the guideline standards. So, for example, they may not be respecting human rights, they may not have a human rights policy, they may not be undertaking due diligence as part of their businesses. Then anybody can make what's called or lodge a specific instance to a national contact point. So this is a really powerful process for being able to hold a business accountable for either a breach of the OECD guideline standards or even possibly a breach of human rights. And what you do, anybody can make that lodge that specific instance, and you fill in the necessary paperwork, the documents that are required, you lodge it with the national contact point, and they will investigate. What they normally do is that they will investigate. If they find that they conclude that the company has failed to meet the guideline standards, they will normally arrange for a mediation to take place between the complainant, whether that be an individual or an organisation, and with the company who is alleged to have failed to meet the guideline standards. And then out of that mediation, there may be terms that are agreed upon between the parties which will be usually terms to stop what's happening and to prevent any further breaches or violations of the guidelines or human rights. If you're not sure whether the national contact point is an appropriate avenue or forum for you to lodge a complaint against a business, I would suggest that you go onto the websites, and you can look at all the various countries. You can go onto the Australian website, if you like, and have a look at some of the kind of specific instances that have been made to the NCPs. They will have the initial complaint or grievance, and you can see how it's been drafted. They will also then have a report. Sometimes they will have an interim report, and then they may have a final report on talking about what have been the outcomes of that specific instance. Before I talk about modern slavery legislation, I thought I would just mention risk-based due diligence and what that actually means when a company is having to undertake that. So risk-based due diligence, it's a key element of responsible business conduct. It's a process through which businesses identify, prevent, and mitigate their actual and potential negative impacts and account for how those impacts are addressed. So that's what risk-based due diligence means. So I'm now going to move on. I've left quite a lot of time for Q&A. So please feel free. I believe there's a question and answer, like a chat box on this platform where you can ask me questions. Please feel free to ask those questions, and I'm more than happy to have, as much as we can on these platforms, have a conversation about business and human rights. So one of the big developments in business and human rights has been modern slavery legislation. Australia has recent, our legislation is very, very recent. It's in 2008 that the federal government enacted the Modern Slavery Act, 2008. United Kingdom has had their Modern Slavery Act, I believe it was 2015. California has a modern slavery diligence type legislation. France and the Netherlands have due diligence legislation as well. They do vary across the world, but in essence, the common denominator is that businesses have to report they have to lodge modern slavery statements every year. Usually at the end of the financial year, they have to lodge a modern slavery statement. The statements have to identify modern slavery risks that and any adverse modern slavery impacts that may be happening in their business. So how does a business actually do this? And I'll also encourage you to go onto the websites where you can actually download modern slavery statements, and you will soon realise that there are some businesses who are doing excellent modern slavery statements. And there are some businesses that are doing very poor modern slavery statements. The poor modern slavery statements are a 1-page or 2-page document that basically just might say that we have a human rights policy, we respect human rights, and this is what our business does, and that will be the extent of it. That does not comply, and it would not comply with the modern slavery legislation here in Australia as to the nature of the modern slavery statements and what the contents, what it actually needs to contain. A modern slavery statement needs to contain an overview of the businesses and the business operations, its people, its activities. You could almost, and some the companies that are doing this really well will drill down and talk about the gender makeup of a business, the demographics, their ages, and ages is important because if a company is using child forced labour, then the ages of those that are employed will indicate whether or not that company is using children as part of its business activity. Once a business then outlines its businesses, its operations, it then needs to also outline its supply chain and in terms of how the business activities are undertaken. Do they source products from various different countries? Where is their supply chain and how far does their supply chain go? Then what a modern slavery statement needs to do is needs to identify what are the modern slavery risks. Are there risks of forced labour? Are there risks of debt bondage? Are there risks of slavery or slavery-like practices? Does the business have a risk of engaging in forced organ harvesting or forced labour in internment camps in China? Those risks need to be identified in the modern slavery statement. And then the other important part of a modern slavery statement is to identify what remedies does that business have in place in the event that there is an adverse impact on human rights through their business activities. That way, if the company identifies at any point or someone makes a complaint within the business or within the company and says, my human rights are being breached, or you're breaching somebody else's human rights in Thailand or in China or in the United Kingdom or in Australia or in Canada, what is that business doing to be able to identify that? And what complaint mechanisms does the business have in place for people to make those complaints? And are there risks within that business that if someone makes a complaint that there's going to be an adverse reaction to the person who made that complaint and then they risk losing their jobs? So the modern slavery statement should not be 1 or 2 pages long. It should be a fairly detailed document that maps out the business's activities, their supply chains, any identified modern slavery risks, and then what they do about once a risk is identified or an adverse impact is identified, what do they do about that? That is a comprehensive modern slavery statement. In Australia, it is now legislated that if a company earns over $100 million, it is a mandatory for that company to report to lodge a modern slavery statement. And we have a register registry. It's an online registry. You can go in and have a look and just put in Modern Slavery Registry Australia, and you can have a look and you can download some of the companies' modern slavery statements. Similarly, in the United Kingdom, they also have a modern slavery registry. They've been doing it a lot longer. So you can go there and you can find hundreds of companies who have lodged modern slavery statements. I think in the United Kingdom, they also, as part of their legislation, need to also put the modern slavery statement perhaps on their website. I'm not sure if that's changed, but that you will also find companies who will put their modern slavery statements now front and centre on their website. And as I said, there are some companies that are doing really well in this regard, but there are other companies that aren't doing so well. So with regard to human rights in China, most people will now be familiar, because it's been all over the media, about the forced labour camps with the Uyghurs in Xinjiang in China. There have been a lot of companies that have been called out regarding using cotton in Xinjiang, because it has been found that it has been used through forced labour, through Uyghurs being the victims of that forced labour. And there are companies now that have stopped trading with China because of the human rights risks that are associated with dealing with companies that are producing cotton through forced labour in Xinjiang. It's really powerful in terms of business, and human rights is a powerful avenue for preventing human rights abuses in China. I would encourage all of you to perhaps consider using the national contact points in your country to lodge complaints, or what they're called specific instances or grievances, but lodge complaints to them so that they can investigate the company if you have concerns that that company is through its business activities is having an adverse impact on somebody's human rights or a community's human rights. Right? I'll just stop sharing there. And so I've left about 15 or 20 minutes for Q&A. I will just have a look. Yes. Somebody has asked a question, and I have thought about this myself. I think about this all the time when I'm working on this issue about human rights in China. This is the question: how does this apply to China that just says nothing and nobody outside of China changes, and what happens in China? Dealing with China head on is often a futile exercise, as we all know. The benefit of using some of these mechanisms, particularly the national contact point mechanism or your modern slavery legislation, is that you're often not dealing with China directly. You're dealing with perhaps a company in your own country that is dealing with a company in China. And what that does is that indirectly sends a clear message to China that they have to look at their own business activities, their own way of, and the way that they treat people, because the international community is going to stop trading with them if they continue to produce products where they are either using forced labour or breaching other fundamental human rights, including the right to life, the right to be free from torture, the right to be free from slavery and slavery-like practices. So it's not about necessarily just dealing with China head-on. It's actually it's a more indirect approach where the rest of the world says, who've got these obligations, says, well, we can no longer trade with you because we have legislation or we have standards which we need to oblige. We have those obligations, and therefore we can no longer trade with you. That is going to put a lot of pressure on China, because one of China's main focus at the moment is being a world leader in trade. So this is how business and human rights can have an impact on China. So I hope that answers that question. Yes, so this is a really good question. Would activities such as training people or research activities be considered part of a supply chain? The answer is yes, it would be. So when a business is mapping out its activities, its operations, it includes absolutely everything, from training people, doing research activities, where are they doing that research, who are they doing that research with, who are they training, are they training, for example, with forced organ harvesting. University here in Australia was affiliated and associated with training organ transplant surgeons over in China. That would be definitely seen as part of the supply chain of that university, and they would have to assess and do their due diligence, human rights due diligence, to see whether or not there are human rights risks in undertaking that research activity or training people. So this is a question, I'll read it out. Regarding the national contact points, do they provide advice? For example, could they advise what level of responsibility medical organisations and hospitals have in regards to collaborations in China, with China in relation to organ transplant research and training? Okay, that's an excellent question, and this is the power of a national contact point. They will investigate, they will make recommendations, and those recommendations will be making recommendations to the organisation or to the company that is in question. So let's say that it is let's say that an individual wants to make a complaint about a hospital here in Australia, as an example, because that hospital is purchasing supplies from a company in China where there are human rights risks. It can't be just any company in China. There has to be a human rights risk of some sort. So you need to do your own important due diligence to say, okay, is a hospital purchasing, let's just say they're purchasing a product that is made by a company in China, and that company in China also makes products for other hospitals in China where they do organ transplants, unlawful or unethical organ transplants, then yes, then you can make a specific instance to the national contact point, because that company in China, you would argue that that company in China is not adhering to the OECD Guidelines standards regarding human rights. So the National Contact Point Centre, they will investigate, they will undertake a mediation between the complainant, if you like, and the company. They will then write a report which will talk about the recommendations that they made and the advice that they provided to that company in terms of what they need to do to ensure, well, one, to stop that adverse impact from happening, and to also prevent it happening in another time. Another question here is, can an individual submit a complaint or only an organisation? Anyone can submit a complaint. An organisation can submit a complaint, and an individual can submit a complaint. Again, the powerful process of the national contact point is that you're not litigating and it's not judicial. So it doesn't cost you anything. What it will cost you is the time to draft your complaint, and then obviously any time involved in attending mediations and in having to respond to any questions from the national contact point in terms of their investigation. They might need some more information. There is no cost consequence, so you're not going to have a court say that you now have to pay the cost of the other party because you've lost. It's not adversarial. It's not about winning and losing. It's about resolving a complaint, and it's about putting things in place so that it doesn't happen anymore. The next question is it likely that hospitals, universities and medical organisations would know about these business and human rights organisations? Another excellent question. It's difficult to know whether hospitals and universities and medical organisations would know about business and human rights organisations. I think that it's still a fairly new field. I think businesses and companies are still grappling with knowing what their obligations are when it comes to business and human rights. What are modern slavery risks? What is modern slavery? I think a lot of the organisations may not even know what modern slavery is. You may not even know what modern slavery is. It's defined differently in different legislation. So I think we have a role as advocates to educate businesses about those human rights obligations. But if there is modern slavery legislation in a particular country, then businesses have no excuse to say that they don't know about their business and human rights obligations. They are legally obliged to comply with modern slavery legislation, and that means reporting a modern slavery statement, and these are publicly available on modern slavery registries in countries that have those registries. So I hope that answered that question. I have another question. What happens to the business if they are found to be breaching? Does it go to court? Okay, so if with a national contact point, it's not judicial. It's the recommendations that come out of the reports that are made are not binding on that business. So it's not judicial. So it's not like a court. If you want to go to court, of course you can take a company to court. There are recent judgments that have just from the United Kingdom regarding Shell in Nigeria. You can look it up on the website. There's just a recent judgment recently saying that companies are now liable for their subsidiary companies for breaches of human rights. It's a very important recent decision that's come out of the United Kingdom to say that if you're a company and you have a subsidiary, that you are liable for what that subsidiary does in terms of any breaches of human rights. So you can go down the avenue if you've got the legislation in that country. You can go down that avenue. But why go down that avenue if you can also get resolution through a non-judicial mechanism that is less stressful, less costly? There are always risks involved in going to court. And also where you could actually get resolution without having to go through a very stressful and costly exercise. I have another question. Does the size of the business make a difference, or are all businesses obliged to adhere to the standards? So with the OECD guidelines at multinational enterprises, multinational organisations are obliged to adhere to the standards. You will find that it's it's multinational enterprises that are obliged to those standards. But don't underestimate what a national contact point will investigate. You can always contact your national contact point and say, look, I've been dealing with this business. Can I make a specific instance against this business? And they will guide you around that. They're not a terribly busy. I know in Australia they're not terribly busy in terms that they don't have a lot of specific instances. So it's good to build a relationship with your national contact point and get information from them and find out what kind of complaints they would be prepared to investigate. Okay, so question, how far along the supply chain is a business responsible? People had different views about this. There's nothing set in stone. Some people take the view that a business is responsible for all levels of their supply chain. Some people would say that businesses shouldn't be responsible for their supply chain that is at a real arm's length, where they are unable to ascertain what is happening when the company in another country is making a bolt for a chair, for example. Some other people would argue that a business is responsible for its entire supply chain. Question here is, if it is not judicial and legally binding, how can we ask the companies to stop businesses even after their engagement in forced labour or organ harvesting is discovered? This is where advocacy is really important. Continual advocacy. Advocacy that is where you're resilient, determined, and you never give up. So while something may not be binding, or it may not be a judicial remedy, that doesn't mean that businesses won't feel the pressure to stop engaging in activities where there are human rights breaches or risks of human right breaches, because the international community is quite powerful. If you have a look at what's been happening with the forced labour in the internment camps with the Uyghurs, there has been a lot of pressure on businesses who are dealing with companies in China who are producing that cotton to say that we no longer will be dealing with you. That is very powerful. So whilst it's not legally binding and it's not a judicial remedy, that doesn't mean that it won't have some kind of impact. Now, for example, if the National Contact Point bring out the report and they make a recommendation that the company needs to stop doing a particular activity because that is associated with a human rights risk or a breach of a human right, and that company continues to do that, then you can go back to the National Contact Point and maybe you can lodge a second complaint, and you just need to keep going until that company stops what they're doing. Or you can use other forms of advocacy, which is working with other advocacy groups who work in the area of business and human rights to put pressure on those companies to stop engaging in those activities. So we have 5 minutes left. If anybody else wants to ask a last burning question, you're more than welcome to. Otherwise, I'm more than happy to come back another time and drill down a little bit more around modern slavery legislation, what's required of businesses. I'm also happy to talk in more detail about how to make a specific instance to the National Contact Point if there is in your country you're concerned about a business, that could be any business, you're concerned that those businesses are engaging in activities which result in risks of human rights breaches, then I'm more than happy to come back and talk a little bit more about and provide a little bit more detail about how you do that. But if there are no other questions, then they say a short meeting is a good meeting. So we get a bit of an early mark. Thank you very much again for attending, and I wish you all well for the rest of the day. Thank you.
Thank you very much, Madeleine. Thank you very much for your engaging and informative presentation, and thank you everyone for attending. ETAC has a number of advocacy initiatives taking place, including a weekly social media emails, petitions that you can support, and legislative initiatives in different regions. We also have a research team in Arabic, Chinese, and English. If you are interested to learn more or know more about it, please reply to one of the emails that you have received today with today's webinar link. We'll also be in touch with you soon with information regarding our next webinar on documenting evidences. Thank you again and see you all next time.